Welcome! Building on our discussion of investor-state arbitration in video 3, we will illustrate here how this type of arbitration relates to public interest. You will come to realize that investor-state arbitration has a direct impact on your daily life with respect to, for instance, the environment and human rights. To allow you to better understand how investor-state arbitration impacts your public interest, we will take the example of the plain packaging regulation in Australia and the claim brought by Philip Morris Asia against Australia. What is this regulation about? What are the claims of Philip Morris Asia? What do they entail for Australia? And more generally, what does this example teach us about investor-state arbitration? These are the main points that we will be addressing together. In 2011, the Australian Parliament adopted the Tobacco Plain Packaging Act. Under this act, it put in place a plain packaging scheme requiring the use of the same color for all cigarette packages and the inscription of brand names in small uniform font. By a separate regulation, the size of the graphic health warnings on the front pack was increased from 30 to 75%. As a reaction to this act, the tobacco company Philip Morris Asia, which is a Philip Morris affiliate based in Hong Kong, brought a claim under the bilateral investment treaty concluded between Hong Kong and Australia. Philip Morris Asia argues that this act breaches various provisions of this treaty. It claims that it is violating the treaty's expropriation provision due to the substantial deprivation of the intellectual property and goodwill, the consequent undermining of the economic rationale of its investment, and the substantial destruction of the value of Philip Morris Australia that it fully controls. Philip Morris Asia also claims that the Australian Act is in breach of the fair and equitable treatment provision of the treaty. This claim is based on the fact that it finds that the Act is substantially impairing its investment. First, because it believes that there is a lack of credible evidence that the measure contributes to reducing smoking, and second, because there exist, according to Philip Morris Asia, effective alternative means to reach this objective. Another tribunal is currently deciding a similar claim brought by another Philip Morris affiliate against Uruguay, which also adopted regulations aiming at reducing smoking. More claims are likely to be brought by tobacco companies, given that numerous countries, especially in Europe, have already passed or intend to pass similar legislations. What do such claims entail for Australia and other states that face arbitration proceedings in which public interests are at stake? First of all, if these arbitration tribunals decide that the states have violated their obligations under investment treaties, then the states will have to pay compensation to these foreign investors. However, it is important not to assume that the claim will be successful, as is often argued by the opponents to investor-state arbitration. Despite the initial claims of foreign investors, empirical studies show that tribunals decide more often in favor of states and that they usually do not regard general regulations as being in violation of investment treaties. But whatever the final decision reached by arbitration tribunals, the risk that states may have to pay compensation and the cost of the arbitration proceedings may dissuade some states from adopting measures aiming to protect or to promote public interests. As is discussed in video 3, this risk exists largely because of the disconnect between the expression of consent by host states and foreign investors. More fundamentally, this means that states are not completely free to regulate in order to protect and promote public interests. Their regulation must comply with the treaty obligations that they have decided to place upon themselves, which leads arbitration tribunals to review the measures that they enact. As I told you in video 3, investor-state arbitration, even if you don't know it or see it, plays an important role in your daily life. For this reason, many argue that the traditional private nature and features of arbitration that are also discussed in video 3, especially its confidentiality, are inadequate. Because of these criticisms, there are ongoing discussions to replace arbitration with other methods to settle investor-state disputes, or to downgrade its supremacy, for instance by giving a greater role to domestic tribunals. This is especially the case in the negotiations of the transatlantic trade and investment partnership that are currently taking place between the European Union and the United States. Another strategy for addressing these criticisms involves adapting investor-state arbitration and making it more transparent. This strategy translates especially into allowing, under some conditions, non-disputing parties, for instance NGOs or international organizations, to file written submissions. For example, the World Health Organization has recently been authorized to file such a submission in the dispute between Philip Morris and Uruguay, which I have mentioned earlier. Other ways to improve the transparency of investor-state arbitration consist in allowing the public to attend the hearings or in publishing more systematically the awards and decisions. The UNCITRAL rules on transparency in treaty-based investor-state arbitration that can be applied in the arbitrations conducted under the auspices of the Permanent Court of Arbitration head in such a direction. All these efforts will allow you to know what happens in the arbitration proceedings and how arbitration tribunals decide these disputes. In that sense, all these efforts obey one of the main adages of the judiciary. Justice must not only be done, it must be seen to be done. This will certainly help to change the perception of investor-state arbitration by the public opinion and to fight the caricature of investor-state arbitration as being pro-investor. In this video, you have come to realize how public interests are at play in investment treaty arbitration through a concrete example involving human health. Furthermore, you have learned about the consequences of investor-state arbitration for states. I invite you to join me in video 5, in which I will be interviewing Brooks Daly, who is the Deputy Secretary General and the Principal Legal Counsel of the Permanent Court of Arbitration.